And today we're going to talk about the possible grounds of challenge to what we've called suspicious wills by reference to a hypothetical case study. So what do we mean by a suspicious will? Well, a testator typically would execute a new will in favour of one or more family members, often to the exclusion of others, or perhaps not in favour of family members, but in favour of others such as friends, neighbours or carers. And that new will represents a significant departure from the terms of previous wills, which may have divided the estate equally between the testator's children or nearest relatives. The terms of the will are therefore surprising or suspicious, at least to the parties who wish to challenge its validity. The testator may have been elderly and or in failing health, and perhaps in the early stages of dementia, or suffering from some illness or a recent bereavement. The testator is typically vulnerable, susceptible to influence, and the primary beneficiary under the will may have been in a position to influence the testator by virtue of their dominating personality or position of trust, and or they may even have been involved in the preparation or execution of the will. And so there is a strong suspicion that the testator either lacked capacity or wasn't actually aware or didn't approve of the contents of the will, or that they were unduly influenced by some sort of pressure, or they acted as a result of lies told by one of the beneficiaries of the new will. Of course, you've got to bring the claim within a recognized legal ground, such as undue influence, fraudulent calumny, want of knowledge and approval, testamentary incapacity, or lack of due execution. And that's what we'll be looking at today. I should just refer to a couple of passages from judgments in the cases which inject a note of caution. As Lord Neuberger said in Gill and Woodall, wills frequently give rise to feelings of disappointment or worse on the part of relatives and other would-be beneficiaries. Human nature being what it is, such people will often be able to find evidence or to persuade themselves that evidence exists, which shows that the will did not, could not, or was unlikely to represent the intention of the testatrix, or that the testatrix was in some way mentally affected so as to cast doubt on the will. But he cautions against judges too readily accepting such contentions on the basis that it would risk undermining what may be regarded as a fundamental principle of English law, namely that people should in general be free to leave their property as they choose. And it would run the danger of encouraging people to contest wills, which could result in many estates being diminished by substantial legal costs. So that's something to bear in mind. Of course, there's going to be suspicion. It doesn't necessarily mean that a claim to set aside the will is going to succeed. And then, as Sonia Proudman said in Nesbitt v. Nicholson v. Boys, the problem in this case, as in so many, is that the parties seem to think that a judge can look into the heart of the witnesses and somehow divine the truth. That is not how the system works. A judge can only find facts on the evidence properly adduced. I cannot tell what actually happened. I can only, as I've said, find facts on the evidence. So of course, it may well be that all sorts of horrible things have gone on in the background, but it doesn't necessarily mean that you've got the evidence to establish a valid claim. So with those introductory words, I'll hand over to Poppy, who will go through the facts of our hypothetical case, and I think there'll be some slides to assist.
So yes, thank you, Charles, for that introduction. First slide is just an introduction, as Charles said, to the main sort of causes of action that we're looking at today, the main ways that you can challenge a will. But now let's look at the problem that we have. So our testator is Jack, who sadly died this year, aged 88, and leaving behind his only son, Paul. Now, in 2020, Jack made a new will, and by that will, he left 50% of his residuary estate to one of his carers, Jill, and the other 50% equally between a number of charities to which he had no special links prior to his death. And that will was prepared without professional help or advice. So prior to executing the will, let's look at Jack's health. Now, he had occasionally expressed a belief that he had been visited by his long deceased mother, but he was never formally diagnosed with dementia or any cognitive impairment. And while his medium to short-term memory wasn't as good as it had been in the past, he could still do lots of day-to-day activities like reading the newspaper, doing the crossword, writing letters, holding rational conversations. In terms of his relationship, Jack's relationship with Paul, his only son, prior to executing the will, or at the time of it, Paul had not been able to visit for some time prior to the execution of the will, but that was because of COVID restrictions. And in fact, prior to the lockdown, Paul had visited 3 to 4 times a year and had assisted Jack with a number of financial matters as well. But even though that was the case, Jack had told people that Paul had not visited him for years and did nothing to help him. Recently, Jack also expressed a general dislike for Paul, which he'd done for the first time. Jack did, however, have a good relationship with Paul's daughter, Tiffany. So Jack had also previously executed a will in 2015, and he did so following the death of his wife. In that will, he made a number of legacies to friends, relatives, and charities. Some of those charities were the same beneficiaries under the 2020 will, but some of them were not. And after those legacies, he left the whole of his residuary estate to Paul, absolutely, if he survived Jack. And if Paul did not survive him, the estate was to be held on trust for Paul's surviving children, equal shares, absolutely. So as we have already referred to, Jill, who was Jack's carer, she's the main beneficiary under the will. What does she say about this? Well, her evidence is that Jack told her that he wanted to make a new will, that he purchased a pro forma draft will, she completed the dispositive provisions by hand on Jack's instructions. She was aware that Jack proposed to include her as a beneficiary, and she says she did protest that the solicitor should be involved, but Jack said that this was unnecessary. She also asked whether Jack had many previous wills, and he said he had not had a will since his wife's death, which of course we know was incorrect because he made the 2015 will. Jill arranged for 2 friends to act as witnesses. Their evidence is that they attended Jack's house, and Jack, obviously because it was in 2020 during lockdown, kept his social distance, but asked them to witness the 2020 will, and he handed that will to Jill to hand to them. The witnesses can't recall whether the 2020 will was already signed or whether Jack signed in their presence. They just signed as they were requested to do so. The 2020 will does contain the regular attestation clause, though. The evidence of the witnesses is also that Jack appeared to be happy with what went on, but they don't say that the 2020 will was read to Jack by anyone when they were present, or that he read it in their presence, or that he made any comments on its contents. So returning to Paul, Paul being the only surviving son of Jack, he's suspicious of Jill's involvement. He claims that Jack found her attractive and indeed was obsessed with her. And he claims that she took full advantage in persuading him to make the 2020 will, which benefited her personally. He also strongly suspects that she made comments to Jack, fueling his apparent and recent dislike of Paul. So those are the facts that we're dealing with. And I'll just hand back to Charles first before we continue on.
Yes, so to sort of pull the threads together, what we have is a suspicious will, the 2020 will, in that it makes no provision for Jack's only child, Paul, or indeed for his daughter, Tiffany, with whom Jack had historically been on good terms. And of course, it's also suspicious because it substantially benefits charities with whom Jack had had no particular connection, and his carer, who obviously had day-to-day sort of access to Jack and was in a position to influence this. And it's in stark contrast to the previous 2015 will, which substantially benefited Paul and his family. There's also evidence of delusionary beliefs on Paul's part, that his dead mother had visited him. He was also suffering, as many old people do, from memory problems. And in most material, there was a failure to remember that Paul actually had visited on regular occasions in the past and had been supportive. And all those matters go to the question of incapacity. But on the other hand, there's no medical evidence of incapacity, and Jack's cognitive abilities still remained intact. There's further suspicion in that there was a sudden onset of dislike, as it were, for Paul on the part of Jack, and that the will was written out by one of the main beneficiaries, i.e. Jill, without any solicitor being present or any doctor or any independent third party. There's yet further suspicion because Jill, of course, is one of the main beneficiaries. She gets 50% of the residuary estate. And there is a suggestion that she had captivated Jack and or disparaged Paul. So there's possible evidence there of undue influence or fraudulent calumny. There's also no positive evidence that Jack read the will or had it read to him, or that he'd even said anything at all about its contents. And that, of course, cast doubt on whether or not he knew and approved of the contents of the will, although he did, of course, refer to the document as being his will when he asked the witnesses to sign it. But there is no positive evidence on the part of the witnesses that they saw Jack actually signing the will. They simply say that they were handed a document which they signed. So that, I hope, brings it together, and perhaps we'll go on now then to look at each individual head of claim, starting with testamentary incapacity, and I'll hand back to Poppy on that.
Thank you, Charles. Well, the test for testamentary capacity is well known. It's that set out in Banks and Goodfellow. So we'll be familiar with that. It's the testator must be capable of understanding the nature of his act, understanding the extent of the property of which he is disposing, comprehending and appreciating the claims to which he might give effect, and not be subject to any disorder of the mind as shall poison his affections, pervert his sense of right, or prevent the exercise of his natural faculties, and that no insane delusion shall influence his will in disposing of his property and bring about a disposal of it, which, if the mind had been sound, would not have been made. Following the appeal in Clitheroe and Bond earlier this year, the High Court has confirmed, albeit technically overturned, that the Mental Capacity Act has not overridden the Banks and Goodfellow test, so this remains good law. This is a test that harks back to 1870, but the courts are prepared to apply it flexibly to each case to take account of developments since it was first established, in particular developments in medical understanding, and this was reiterated by Ms. Justice Falk in Clitheroe and Bond. And it's flexible enough that it doesn't prevent an elderly testator who perhaps even suffering from dementia or just doesn't have a very good memory anymore from making a will. The burden, it's with the propounder of the will to establish capacity, but where a will is duly executed and rational on its face, the court presumes capacity. And then what happens is the objector has to raise a real doubt about capacity. And if they do so, then the evidential burden will shift back to the propounder.
Just this one point, that what we're looking at here is capacity to understand rather than actual understanding. So, for instance, it's now recognized as an adult with impaired mental capacity is capable of making some decisions for themselves given help. So the question is not necessarily whether or not you actually understand the extent of your property, it's whether or not you would be capable of understanding it if you were told what the extent of your property is. So that's just that small point. But it is quite important because there's a difference between testamentary capacity and knowledge and approval. One of them goes to capacity to understand and the other one to actual understanding. But with that, why don't we go on and look at the next slide about mistake?
Yes, so Jack has this mistaken belief, doesn't he, Charles, that Paul has not visited him for some years and also did nothing to help him, which we know is not true, because Paul actually visited him 3 to 4 times a year and assisted him with a number of financial matters.
Yeah, so that gives rise to the question, doesn't it, whether or not you can apply to set aside a will simply on the grounds that it's come into operation as a result of the testator's mistaken belief as to some material fact. Is mistake a ground of invalidity? And I think the answer to that is given by the case of Ball and Bull, which is on the slides. There, the testatrix had made a will excluding 3 children who'd claimed to have been sexually abused by their father. And those children claimed that the testatrix was labouring under a serious mistake in the form of her belief as to her husband's innocence, which deprived her of testamentary capacity. But it was accepted that she wasn't suffering from any other physical or mental illness. On the claimant's case, she'd simply made a mistake, and the judge found that the mistake did not operate to invalidate the will. It was not in itself a severe affective disorder, although it might be a symptom of a pre-existing condition, and it wasn't in itself the cause of loss of capacity. So mistake on its own, not enough.
Yes, but they did also say in Ball and Ball, didn't they, that even though mistake on its own isn't enough, in an appropriate case, you could say that the testator was suffering from an insane delusion, and so that would affect their testamentary capacity. So I think the question then becomes, could we say that Jack's mistaken belief could amount to an insane delusion?
Well, let's go on and consider what is meant by a delusion as a matter of law. It is part of the Bank and Goodfellow test that there should be no insane delusion which influences the will and the testator in disposing of his property and bringing about a disposal of it, which, if the mind had been sound, would not have been made. So it's there, as it were, in the wording of the Banks and Goodfellows test. So what is a delusion? Well, there's certainly a delusion if no person in possession of their senses could have believed what the testator believed, such that the belief must have been the product of insanity. And that is to be contrasted with a simple mistake, which is attributable to poor memory. The key question, as set out in Clitheroe and Bond, is whether or not the relevant irrational belief is fixed. And what that means is that the testator must sort of rigidly cling to a false belief, which is in effect groundless. There's no basis. It's contrary to the facts as known to the deceased. So in that case, in Clitheroe and Bond, the testatrix had suffered a delusional belief that her daughter had falsely accused the testatrix husband of sexual abuse, which had broken her parents' marriage. And that belief was demonstrably false because there was evidence of letters from the husband detailing the abuse, which had been used in the parents' divorce case. So there you had a fixed belief, which was contrary to the facts, which could easily be established and those facts were known to the deceased, so it was something which was delusional.
Mm. So in the present case, we've got Jack believes that Paul just hasn't visited him for many years and has done nothing to help him. Do we think that's a delusion? I mean, it might just be the case that Jack has forgotten. And after all, Paul hadn't visited during lockdown, so maybe for a year or so. So it's quite easy to see that Paul might simply have forgotten, but if he'd been corrected, then he would have accepted that that was the truth, that Paul did used to visit before then.
Yeah, so that's probably not a delusion, but what about Jack's belief that he'd been visited by his long deceased mother? Does that qualify as a delusion?
Yes, quite an irrational belief in that. I mean, that, you know, obviously if his mother is long deceased, she can't have come to visit him. No one in possession of their senses could really believe that. It seems to me to fit squarely in the category of delusions. But the issue here is that needs to be that causal link between the delusional belief and the disposition. And I mean, we referred to the two cases of Ledger and Wooten there, and Lloyd and Jones. In Ledger and Wooten, the testatrix had these paranoid ideas or delusions of persecution, but the evidence didn't establish that any particular delusion directly influenced the actual terms of the will. And in Lloyd and Jones, the judge found that the testatrix suffered from dementia and heard voices and suffered delusions, but it was accepted that the delusions were only relevant if they affected the dispositions made. And it was not, even though the delusions were bizarre, it was not suggested that they could have had any such effect in the case.
I suppose if the dead mother had said to him, apparently, you know, cut out Paul from your will, he's a wrong un.
Yes.
Then possibly the delusional belief might have been causative. But if you just believe all sorts of strange things, you believe that there are fairies at the bottom of your garden, there's no causal link there necessarily between that belief and the will that you've made. Of course, those delusional beliefs may be generally evidence of incapacity.
Yes.
But that's another matter. That doesn't mean that they're delusional as such.
Yes. So we go on now. We can consider the forgetfulness, because Jack's clearly suffering from some forgetfulness, because he's forgotten that he executed the 2015 will, as he said that he hadn't executed one since his wife's death. But I think this goes back to what you were saying at the start, before we sort of dove in, Charles, that we're focusing on capacity to understand rather than necessarily, we're not focusing on forgetfulness. It's not a test of memory, the testamentary capacity test.
No, that's right. As was made very clear by the Court of Appeal in Simon and Byford, where the testatrix had forgotten not only the terms of her previous will, which had benefited her son Robert, but also the reasons that she had had for making that will. But the Court of Appeal made it quite clear that the fact that you've forgotten something doesn't mean that you're incapable of remembering it. If she'd asked for the will, she would have understood it. And Lord Justice Lewison made a good comment about the fact that once he'd known the dates of all the kings and queens of England and the formula for Hooke's law, he'd now forgotten them, but it doesn't mean he was incapable of understanding them if they were put to him again and he looked at them again. And so that's the way that you've got to look at it as far as incapacity is concerned. So we probably conclude, wouldn't we, on the basis of that his forgetfulness of the terms of his previous will in itself wouldn't be sufficient to found a claim for testamentary incapacity.
Well, and a testator doesn't have to justify himself about a difference between a previous will and a new will, even if there are particular reasons for the terms of the previous will. And that was made clear in the Goss, Cussard and Templeman. That was the case involving Lord Templeman's will, who famously established the golden rule. And there it was reiterated, that test, what was said in Simon and Byford about how capacity depends on the potential to understand, and not that test of memory. Continuing on, we looking at the part of the Banks and Goodfellow test, that limb that says that the testator has to comprehend and appreciate the claims to which he might give effect. Because here Jack had originally made a number of legacies to relatives, hadn't he? And there's also the fact that even if he's decided he doesn't like Paul, there is Paul's daughter Tiffany, who he's always had a good relationship with, hasn't he? But a testator needs to be capable of recollecting all the persons whom he might reasonably wish to benefit and the nature of their claims. And we cited two cases there. We've got Harwood and Baker, and Abbott and Richardson. In Harwood and Baker, there was a will executed by a testator on his deathbed in favour of his wife and excluding other members of his family. And the testator was in ill health at the time, and the will was a departure from and contrary to his previous intentions. And there it was held that a testator must not only be able to understand that by his will he's giving the whole of his property to one object of his regard, but he must also have the capacity to comprehend the extent of the property and the nature of the claims of others, who by the will he's excluding from participation in that property. And that's quite an old case, but there's also this more recent case of Abbott and Richardson, which the facts of that case aren't entirely dissimilar from the facts that we've got at hand. We had the testatrix, she was quite old, she was 98 when she died, and she made a new will 8 months before her death, leaving nothing to the beneficiaries under her previous will, and left a significant portion of her estate to someone who had worked for her as a cleaner and a carer and a companion for about 6 years prior to her death. And it was held in that case that she wasn't able, without assistance, to recollect, understand, or focus on all the persons whom she might reasonably wish to benefit, in order to arrive at a rational decision about which of them she wished to benefit in what way. And I thought that was sort of quite similar to this case, because we don't know that Jack was reminded about all these relatives and Tiffany who might wish to benefit. What did you think, Charles?
Yeah, well, I think, you see, we've already discounted the fact that Jack's belief that Paul had not visited him didn't qualify as a delusion. Mm-hmm. And his belief that his dead mother visited him, that might have been a delusion, but it didn't cause him to make the will. But nonetheless, if you put together all the evidence of his forgetfulness, his false beliefs about how he'd been effectively abandoned by Paul, these strange beliefs about his mother, the fact that he doesn't seem to have considered in his last will all the sorts of people that benefited under his previous will, you put all those things together, it begins to raise a real doubt as to whether or not he was actually capable of comprehending the whole full range of people, such as Paul, Tiffany, his friends, other charities, etc., that he might wish to benefit. And I think the key thing is it's not enough simply to say that he wanted to benefit, or was capable of understanding that he wanted to benefit the charities and Jill, his carer. He's also got to be capable of having in mind the claims of everybody. Mm. And there seems to be quite a lot of doubt if you put all these things together as to whether or not he would satisfy the limited test about being capable of comprehending the sort of claims on his bounty, the moral claims of Paul, Tiffany, and others that he would be expected to consider. So that's probably the best sort of line of attack, which might also go together probably with the fact that arguably here we have a perversion, as it were, of his sense of right. You've got rather a surprising will. Okay, his cognitive abilities appear to be intact, but certainly if there were grounds for saying, well, look, there's no real sensible basis for why he should have taken such a strong dislike to Paul, and cut him out from all benefit under his will, that in itself might qualify as some perversion of his sort of moral sense, which poisoned his affections and rendered him incapable of making a valid will. And there are a couple of cases, aren't there, Poppy, where the court came to that conclusion.
Yes.
Chalfin Adam and Marie Ashkettle.
Yeah, so we think there's probably enough to raise a real doubt, but obviously we need to prove this. So thinking about the evidence, I mean, as you said at the beginning, Charles, we haven't really got that much medical evidence in our problem. Fact.
No, because I mean, it's often the way that there won't be anything in the medical notes to say, you seem confused, or, you know, you couldn't remember various things particularly, or anything like that. You know, he did the crossword, he read the newspapers, he was capable of having rational conversations. But there is a suspicion that there is an underlying issue here. As I say, his sense of right may have been perverted in some way. What he has somehow formed an irrational dislike for his son Paul on the basis of a false belief that he's been neglected by his son. And these are the sorts of things I think you'd have to instruct a specialist in sort of mental capacity to produce a report about, you know, the effect of possible delusional beliefs, forgetfulness, all the things that we have identified, and to come to a view as to whether or not that was incompatible with testamentary capacity or not. And also, I think the evidence of lay witnesses can be very important, because they're the ones that actually have contact with the testator. And, you know, they can often have very valuable things to say.
Yes. Right, so that's capacity. So should we move on to thinking about knowledge and approval now?
Yeah, let's do that.
So we've put up there a sort of summary of some of the elements of knowledge and approval. The testator has to know and approve of the contents of their will. And so a will executed in ignorance or without acceptance of those contents is going to be invalid. And sort of, it's been said that the question is whether the contents truly represented the testator's testamentary intentions. That was in Fuller and Strum. Also in Gill and Woodall, the court said, it was said that the court should ask whether the testator understood what was in the will when he signed it and what its effect would be. So knowledge and approval needs to be proved in every case. But again, we've got this shifting burden. So the presumption of knowledge and approval arises where the testator has capacity and the will's been duly executed. But then, and then the burden shifts to the objector to the will. But if there are suspicious circumstances, such as, for example, a beneficiary who takes a substantial benefit under the will being involved in the making of it, then this will cause the burden to shift back to the propounder.
So Poppy, are there, do you think suspicious circumstances?
Yes,
in this case?
I certainly think there are. Jill is now a pretty substantial beneficiary, taking 50% of the residuary estate. There's been no professional involvement, and Jack just ordered this pro forma will, and then she filled it out. She got two of her friends to come along and witness the will. And there's no evidence from anyone apart from Jill, even from her, from these witnesses, that Jack read the will. So I think there are sufficiently suspicious circumstances, and I think they bear some similarity to that case Turner and Fithian, the claim of their sort of declaration that the will of their deceased aunt was invalid. The will had left everything to these defendants who, after the death of the deceased husband, they'd begun to visit her, they did her grocery shopping, they drove her to events, they assisted her in moving out of her home and then looked after her home once she'd moved out. And that will had been prepared by one of the defendants. And he said that the deceased wanted to make a will, but she refused to see a solicitor. And in that case, it was held that she didn't have capacity, but also that she didn't know and approve of the will's contents. So I think we do have these sufficiently suspicious circumstances to shift the burden onto Jill.
Yes. So let's have a look at what there may be said against that. What goes the other way? Because even grave suspicions may be rebutted by evidence that the testator probably, on balance of probabilities, knew and approved of the contents of the will. Yes, of course, if a significant beneficiary is substantially involved in the whole execution process, the burden is pretty high, isn't it, on them to prove that the testator actually did know what was in the will and acknowledge that represented their wishes. But it's quite interesting to look at the case of Hart and Dabbs here, where the circumstances could not have been more suspicious. I mean, the propounder of the will had prepared on their computer the will, under which they and their wife took substantial benefits. They'd arranged the execution of the will, and they were even, to make even matters worse, they were alleged to have killed the testator unlawfully. There was no professional involvement of any kind in the will-making process, and no evidence that the testator prepared the will themselves or gave instructions for its preparation. No evidence that the testator read it or had it read to them or they retained a copy, nor apart from one inaccurate statement of the deceased was there any evidence the deceased knew about its terms at all. So you think that's a pretty much open and shut case, but in fact there was evidence from the attesting witnesses that the will had been duly executed, and when it was executed during the signing ceremony, reference had been made to the fact that the purpose of the attendance of the witnesses was to witness the deceased signature. So that led to the conclusion that the deceased was not deceived as to the nature of the document he was signing, and the will wasn't particularly complex or difficult to grasp. As long as the deceased read it, he wouldn't have had any difficulty in understanding, taking in its provisions. And the evidence showed that the deceased was alert and not likely to have allowed himself to be persuaded to do something he didn't want to do. So, and Fuller and Strum was much to the same effect, where one of the beneficiaries had played a major role in the preparation and execution of the will, and no solicitor was involved. But on the balance of probabilities, it was likely that he knew what was in the will. So what about the evidence in this case about what the testator might have known? Poppy, have you got any? Or shall I deal with that?
Well, I mean, the 2020 will, it's not complex, is it? It's
no.
50% to Jill, 50% to some charities. So he'll probably be able to understand that. And we've got the evidence from the attesting witnesses. He handed it to Jill to hand to them. And Paul has, he has expressed this dislike for Jack. So, Jack has expressed this dislike for Paul. So it's not a sort of completely, it sort of fits, it's consistent with what's happened already, I would say.
Well, he had it in his possession on our facts of our case. And he hands it over by Jill to the witnesses saying, can you witness my will? So he knows that although there's no positive evidence that he sort of read its contents or anything like that, he had it in his possession. He knew that it was a will, and he's handing it over to the attesting witnesses. So in all probability, you would think he probably knows what's in it. Now, of course, I think it much would depend in this sort of case on the view that the court might take about the evidence of Jill.
Yes. No,
As the carer. I mean, I think possibly if there were sort of evidence of some sort of dishonest or underhand conduct, but possibly even if there wasn't, but particularly if there was, then the court might end up saying it wasn't satisfied that the burden had been discharged of the testator knowing and approving what was in the will. But on balance, you'd think he probably did know and approve it.
Well, speaking of underhand conduct, should we move on then to undue influence?
Yeah.
So undue influence, it's quite difficult to establish in the context of a will. There's no presumption of undue influence in testamentary dispositions of assets, and the burden lies on the person alleging it. It is the sort of civil standard, but given the seriousness of the allegations, it's going to require more cogent evidence. And there needs to be proof of actual coercion, which is pressure that overpowers the volition without convincing the testator's judgment. Mere persuasion is not enough. And indeed, as we put on the slide, the authorities refer to victimization, domination, and coercion. So this is sort of very, it's quite strong, the language that is used. It's not just physical violence. There can be verbal bullying, or even just this sort of drip talking to someone to sort of overpower their will. And when looking at that, the physical and the mental strength of the testator are relevant factors in determining how much pressure is necessary in order to overbear the testator's will. The elements that a person making such allegations must establish were helpfully broken down by Miss Justice Norris in Wharton and Bancroft. The claimant needs to establish, whether by proof or inference, the opportunity to exercise influence, the actual exercise of influence, the actual exercise of influence in relation to the will, that the influence was undue, so as we discussed, went beyond mere persuasion, and that the will before the court was brought about by these means. Turning then to the facts that we've got before us.
Well, should I just say before that, I want to just draw a distinction between cases where there's direct evidence of undue influence and those where you have to infer it. Usually speaking, there's never going to be any direct evidence of undue influence. You're not usually going to have some sort of letter which says, unless you make this will, you never see your grandchildren again, something of that nature. And this is one of the problems, because although it may be possible to infer that there's been undue influence from all the circumstantial evidence, it used to be said in the authorities that the court wouldn't infer undue influence if there was a plausible alternative hypothesis for what had happened. Or in other cases, it said you can only succeed in such an undue influence claim if there's cogent evidence of undue influence. And so it is obviously going to be very difficult in most cases to prove undue influence. But let's go on to the facts as we're about to do, because the other point is what does undue influence or coercion mean? Is seeking to persuade somebody to do something, does that amount to undue influence? So,
yes, I mean, because here I have to say we don't have direct evidence of coercion, but as you've said, Charles, that's not necessarily surprising, and we can infer that from the circumstances. But and we referred to the case of Schrader and Schrader, that was a classic case of being inferred from the circumstances rather than having any direct evidence. But it's important to know that influence doesn't necessarily, it's not necessarily undue. So in the case of Hubbard and Scott, for example, the testator left his entire estate to his young female cleaner, and died, I think, 11 days after the will's execution. And there's a sort of suggestion that he found the cleaner quite attractive. I think there'd been some discussion of marriage and so on. But it was held that on the evidence just simply did not amount to undue influence. And this distinction needed to be made between legitimate persuasion and overbearing the testator's volition. So harking back to that language we used before, there needs to be evidence of sort of victimization or coercion or domination. And in that case, in Hubbard and Scott, there simply wasn't, and there wasn't also a mental frailty on the part of the testator. And that could be said to be the case here. I mean, Jill might have, she might have, persuaded him, and she might have charmed him, but that doesn't mean that she has exerted undue influence over Jack.
No, a man can succumb to the fascination of a younger woman, or it could be the other way around, or whatever. And that doesn't necessarily mean that there's been undue influence. And she might have, gone along with that. She might have seen an advantage to be taken by playing up to his sort of fancy for her. But that doesn't amount to undue influence. I'm sure, relatives such as Paul might be outraged by her behaviour. I think it's most underhand. And she's got at him, hasn't she? But as I say, it doesn't amount to undue influence, and that's quite a limitation. In this case, the evidence from the witnesses, wasn't there, that Jack seemed to be quite happy.
Yes.
At the will signing process, and so as was said in Hubbard and Scott, the testator was happy to succumb to the cleaner's influence. He was led, not driven, and that's the distinction.
Yes.
What about fraudulent calumny?
Yes, exactly. So fraudulent calumny, that's where an individual poisons the testator's mind against someone who would otherwise be a natural beneficiary of the testator's bounty by casting dishonest aspersions on their character. And in those circumstances, the will be set aside. The person alleged to have been poisoning the testator's mind must know that the aspersions are false or be reckless as to whether they're true or false. And the necessary elements were helpfully broken down in Kinnicky and Hayward. So it's the false representation to the testator about the character of the beneficiary for the purpose of inducing the testator to alter their testamentary disposition. Again, knowledge that it's untrue or reckless as to the truth. And there must be this causation. So the disputed will must be made because of the fraudulent calumny. And we know here that Paul has thought, hasn't he, that Jill has been saying, making aspersions on his character. That's what he suspects. But he can't actually prove any statements. We haven't been referred to any statements, have we, Charles?
No, what you've got, haven't you? You've got evidence of beliefs on the part of Jack about Paul, that he hasn't visited him at all, and this dislike for him which suddenly comes on, which does of course give rise to a suspicion that this has been implanted in Jack's head by the wicked carer who has charmed and captivated him and got him to sign a will which gives up half of his estate. But it's very difficult to prove that sort of thing. In Clitheroe and Bond, which is one of the cases we mentioned earlier, the testatrix had all sorts of false beliefs about her daughter. For instance, that her daughter had ransacked her bungalow and committed other thefts. They were held, in fact, to be delusions which affected her capacity, rather than the result of any fraudulent statements. There was, I think, at first instance in that case, a claim based both on incapacity and on fraudulent calumny, but the fraudulent calumny claim didn't succeed, presumably because there was insufficient evidence. And on appeal, they didn't pursue that point. So it's very difficult unless the surrounding circumstances are pretty compelling as they were in Marcu and Christodoulidis, as the court found, it's very difficult to show fraudulent calumny.
Yes, and we refer to those two cases there of Nesbitt and Nicholson and Rear. Again, those were cases where claims of fraudulent calumny were made, but neither were made out. In Nesbitt and Nicholson, it was held that the daughter who had made the statements, wrongly or not, believed in the truth of the statements she had made, so that the elements of fraudulent calumny wasn't made out. And in Rear, it said that the case was essentially based on inference and supposition on the claimant's alleged bad character, which the court had rejected, and it was held that the deceased had acted of her own free will.
Well, actually, that's another difficult element, isn't it? I mean, it may be that the deceased has got this idea in their head, but if it's their idea, then it's not, never mind what somebody has said. Then you don't make out the claim.
Yes.
So lastly, what about execution, due execution?
Yes, so this is Section 9 of the Wills Act. We'll all be familiar with. A will has to be in writing, signed by the testator or by some other person in their presence and at their direction. And by that signature, the testator must intend to give effect to the will. And the signature must be made or acknowledged by the testator in the presence of two or more witnesses present at the same time. And each witness must either attest and sign the will or acknowledge their signature in the presence of the testator. And we've referred to the case of Reed Sherrington there, because the witnesses must also intend that their signature is in attestation of the document, so they can't have appended it for some other reason, not realising it was a will, for example. There is this presumption of due execution, and that arises whenever a will, which is regular on the face of it and apparently duly executed, that means that this presumption of due execution will arise, and there'll be an inference in the absence of evidence to the contrary that the requirements of Section 9 of the Wills Act have been complied with. In the facts that we've got before us, we've got that the witnesses can't recall whether Jack signed the 2020 will in their presence, and they also can't recall whether it was signed before they were present and when they were present implicitly acknowledged by Jack. What do you make of that, Charles?
Well, you see, the court's generally reluctant to invalidate wills on the basis of technicalities. That's why you have a presumption of undue influence. And where witnesses, I think, simply say that they can't quite remember whether the right procedure was adopted, I think the court, generally speaking, and this is the effect of Sherrington and Canon and Perkins, the court's going to say, well, no, never mind. Particularly if it was some time ago, although this particular will was I think, in 2020. Failures to recollect are not going to necessarily invalidate the will. So I think that's an important point. And as far as the intention to attest the signature, I mean, if the witnesses have signed something has an attestation clause, effectively saying that they are, by their signature, attesting the testator's signature, generally speaking, you're not going to look behind that, even though there may not be some sort of positive statement in terms by the witnesses that they intended to test the signature. I mean, in this case, I think we have assumed that they were simply handed the document, told it was a will, and asked to sign it. Well, that's probably enough.
Yes.
So it's likely, I think, that that ground will not succeed. So why don't we just sum this up then? So there's no freestanding claim that the will is void for mistake. Mistake in itself isn't enough. Although there's a delusionary belief it didn't cause the will to be made, the forgetfulness of the terms of the 2015 will isn't enough. But the evidence, generally speaking, of forgetfulness, false belief, delusions, etc., does call into question Jack's capacity. And his strong, sudden, and surprising dislike for Paul also raises an issue whether or not there's been some perversion of his sense of right and wrong. And so that it is possible, I think, that the will is invalid due to incapacity, but much may depend upon the expert evidence. Lack of knowledge and approval, I think, is a runner because a major beneficiary was involved in the execution of the will, and there's no evidence that Jack read the will or knew its contents. But he did ask the witnesses to witness the will, and I think if he was in his possession, he certainly would have been capable of understanding it if he'd read it. So probably he did know and approve of the contents of the will, although that, as I say, is a possible claim. Undue influence, very difficult to establish. The fact that he might have been infatuated with Jill and she took advantage isn't going to be enough. Fraudulent calumny, also very difficult to prove, even though he may have had false beliefs. We can't establish, I think, probably that Jill had dishonestly implanted those beliefs in his head. And due execution, although there's some sort of evidence of that they're not quite sure whether they did it all properly, that's probably going to be overlooked and the presumption of due execution applied.
And yes, I hope you enjoyed today's session.
Yes, goodbye. Bye, everybody.